Before we begin, a quick and important disclaimer. The following content is for educational and entertainment purposes only and does not constitute legal, financial, or professional advice. The field of family law and media relations is subject to specific state regulations and ethical guidelines that vary significantly across jurisdictions. The case studies and strategies discussed represent historical analysis of public media campaigns and should not be interpreted as a guide for personal legal action. Viewers are strongly advised to conduct their own due diligence and consult with a licensed attorney in their specific jurisdiction regarding any personal legal matters. The most powerful man in a Manhattan courtroom isn't always the one sitting behind the mahogany bench. In the high-stakes world of New York and Los Angeles elite divorces, the real trial often concludes before a single motion is filed. While most attorneys are buried in stacks of financial discovery and prenuptial boilerplate, a select few have mastered a darker, more potent art, the trial by media. Imagine a scenario where a billionaire tech mogul wakes up to find a coordinated three-pronged character assassination across the front pages of the New York Post, the Daily Mail, and Page 6. Within 48 hours, his public valuation drops, his board of directors is panicking, and his leverage in a $500 million settlement has evaporated. This isn't a coincidence. This is a precision-engineered media campaign orchestrated by a historical heavyweight of the legal world. Today, we are pulling back the curtain on the architectural blueprint of how one specific historical U.S. divorce attorney didn't just win cases, but manufactured the reality in which those cases were decided. By the end of this deep dive, you will understand the psychological triggers, the calculated leaks, and the shadow PR tactics that have shaped the most expensive separations in American history. If you are watching this, you probably realize that the traditional justice is blind mantra is a polite fiction when hundreds of millions of dollars are on the line. In the modern attention economy, reputation is the most liquid asset a person owns. Whether you are an executive, an entrepreneur, or simply someone who understands that information is the ultimate weapon, this masterclass solves a fundamental problem. It teaches you how to identify and deconstruct high-level narrative manipulation. We are moving beyond the basic he said, she said drama. We are analyzing the structural mechanics of how a legal team can weaponize the First Amendment to bypass the traditional constraints of the courtroom. We are looking at the pre-litigation narrative launch, a phase where the attorney acts more like a film director than a litigator, casting their client as the sympathetic victim and the opposition as the irredeemable villain long before a judge ever hears a word of testimony. To understand how this attorney revolutionized the industry, we have to look at the historical trend of the news cycle hijack. In the late 20th century, the legal standard for divorce shifted in many states toward no fault, which theoretically removed the need for proving adultery or cruelty. However, while the law became more clinical, the public appetite for scandal only intensified. This attorney recognized a massive strategic opening. If you couldn't use fault to win a legal advantage in the eyes of the law, you could use moral failing to win a psychological advantage in the eyes of the public. This creates a secondary, invisible court where the rules of evidence don't apply. We will be examining the step-by-step process of the Friday night dump, a tactic used to release damaging information about an opponent just as the weekend news cycle begins, ensuring the story marinates in the public consciousness for 48 hours before a legal response can be mounted on Monday morning. Consider the case study of a high-profile 1990s celebrity divorce. The attorney in question didn't start with the summons. They started with a whisper campaign. This involved the systematic distribution of non-attributable background info to key columnists. We are going to break down the information ladder technique. The attorney begins by leaking a minor, verifiable fact to a low-tier tabloid. Once that fact is published, it creates a source of record. The attorney then takes that published article to a mid-tier lifestyle magazine as proof of an emerging story. By the time the story reaches a major national newspaper like the New York Times or the Wall Street Journal, it has been validated through multiple layers of the media ecosystem, even if the original fact was a carefully curated half-truth. This isn't just PR. It is the tactical deployment of social proof to force a settlement. The depth of this strategy goes even further into what we call litigation PR synergy. This is the practice of synchronizing legal filings with press releases, so that the media receives the story version of the lawsuit at the exact moment the clerk stamps the document. In many of these historical campaigns, the complaint filed in court was written more for a journalist's lead paragraph than for a judge's legal review. The language was evocative, the allegations were cinematic, and the quotes were prepackaged for the nightly news. This creates a first-mover advantage. In a divorce, the person who speaks first defines the boundaries of the debate. If the husband is labeled a spendthrift, or the wife is labeled neglectful in the initial headline, the opposition spends the rest of the litigation on the defensive, trying to prove a negative. We will analyze the data on how public perception of a litigant can subconsciously influence the settlement posture of the opposing counsel, who may advise their client to pay a premium just to make the headlines stop. We are also going to explore the third-party validation pillar. This historical attorney was a master at utilizing independent experts who were anything but independent. They would curate a network of psychologists, financial analysts, and social commentators who could be called upon by news programs to provide context on the divorce. These experts would speak in generalities that just happen to perfectly mirror the attorney's specific narrative for that case. This creates an echo chamber of perceived truth. When a viewer sees a news segment where 3 different experts agree that a certain behavior is a sign of financial instability, and then sees a headline alleging behavior in the attorney's current case, the conclusion is drawn for them without the attorney ever having to say a word. This masterclass is going to take you through the 10 specific phases of a media-driven legal campaign. We will start with the information audit, where the attorney identifies every potential skeleton in both their client's and the opponent's closet. Then we move to the planting, followed by the escalation, and finally the endgame, where the media pressure becomes so suffocating that the opposition agrees to terms they would have laughed at in a vacuum. We are talking about potential outcomes where a settlement is reached for 30% more than the legal fair market value, simply because the price of a restored reputation is worth more than the cash. By the time we finish part 10, you will have a forensic understanding of how power really operates in the upper echelons of the American legal system. You will see how a historical U.S. divorce attorney used the media as a high-pressure hydraulic press, slowly squeezing the opposition until they had no choice but to fold. This isn't just about divorce. It's about the mechanics of influence, the psychology of scandal, and the brutal reality of how the truth is manufactured in the 21st century. Prepare yourself because we are going deep into the archives of the most calculated legal minds to ever grace a courthouse steps. This is the art of the media war. To understand the mechanics of this media war, we must first dissect the foundational stage of any high-stakes legal campaign, the strategic vulnerability assessment. This is not a simple background check. In the early stages of a high-profile divorce, the historical attorney would assemble a team that resembled a private intelligence agency more than a legal clerkship. Imagine a scenario in 2026 where a prominent tech executive, let us call him Julian Vane, is entering a dissolution of marriage with his spouse of 15 years. The attorney does not just look at bank statements. They initiate a 360-degree digital and social audit. They look for the discrepancy between Julian's public persona, the disciplined, family-oriented innovator, and his private data footprint. The goal here is to identify what we call the narrative fracture point. This is the specific area where a legal opponent is most susceptible to public shaming or professional fallout. For a CEO, the fracture point is usually boardroom stability and investor confidence. For a political figure, it is moral consistency. The attorney historical trends show that the most effective media campaigns do not invent lies. They find a small, uncomfortable truth and magnify it until it blocks out the sun. By analyzing years of case studies, we see that this attorney would often spend the first 30 days of a case doing nothing but gathering leverage, creating a dossier of every controversial email, every questionable expense, and every disgruntled former employee who might be willing to talk to a reporter under the right circumstances. Once the vulnerabilities are mapped, the attorney moves into the phase of controlled information seeding. This is the delicate art of the off-the-record briefing. In the United States media landscape, journalists are under constant pressure to deliver exclusive content. The attorney leverages this hunger by offering a trade: high-value, verifiable information in exchange for favorable framing. They do not send a formal press release. Instead, they might meet a trusted columnist for a quiet lunch at a high-end Manhattan bistro. They drop a hint. They suggest that there are some very interesting filings coming down the pipeline regarding Julian Vane's offshore holdings, or perhaps his erratic behavior during a recent company retreat. This creates a psychological phenomenon known as the availability heuristic. When the journalist eventually sees the legal filing, they have already been primed to interpret the information through the lens the attorney provided. This is how you manufacture a consensus. Step by step, the attorney builds a network of media allies who feel like they are getting an inside scoop, when in reality, they are being used as the delivery mechanism for a prepackaged legal narrative. We see historical trends where the most successful attorneys in this space actually maintained a spreadsheet of journalists, categorized by their leanings, their past coverage, and their willingness to prioritize speed over deep fact-checking. Now imagine the tension rising. It is 3 days before the official court filing. Julian Vane is unaware that his entire reputation is about to be dismantled. This leads us to the concept of the preemptive strike. The attorney knows that the first person to define the conflict usually wins the public relations battle. Historical data suggests that the initial headline about a divorce often becomes the permanent mental anchor for the public. If the headline reads Vane accused of financial malfeasance in divorce, that is the label he carries forever, regardless of whether the allegations are proven in court. To execute this, the attorney uses the complaint as a narrative weapon. In a standard legal setting, a complaint is a dry recitation of facts and law. But for this attorney, the complaint is written for the New York Post. It uses vivid, evocative language. Instead of saying the defendant spent money excessively, the filing might describe a lavish multi-million-dollar party thrown on a private island while the company was laying off staff. The attorney knows that a judge might strike those details as irrelevant later, but by then the damage is done. The details have already been tweeted, shared, and discussed on cable news. This is a strategic use of the judicial privilege, which protects attorneys and their clients from defamation suits for anything said in a court filing. It is a legal loophole that allows for a massive character assassination under the guise of a formal petition. Let us look at a specific case study involving a historical U.S. sports icon. The opposing side was prepared for a quiet, private mediation. However, the lead attorney for the spouse decided that a private settlement would not yield the maximum financial result. They needed to create a situation where the athlete's endorsements were at risk. They timed the filing of a domestic grievance to coincide exactly with the launch of the athlete's new global marketing campaign. The media firestorm was so intense that the athlete's sponsors began calling his agent within 4 hours of the news breaking. This is the use of the financial chokehold. By attacking the opponent's ability to earn a living or maintain their professional standing, the attorney forces them to the settlement table not out of a sense of justice, but out of a desperate need for survival. The precision of these campaigns also involves the management of the client. A viral U.S. channel's audience needs to understand that the client is often the most difficult variable to control. This historical attorney would often put their own client through a media boot camp. They were coached on how to look, how to walk into the courthouse, and how to maintain a stoic, dignified silence in the face of shouting reporters. This is the victim-survivor pivot. The client is coached to never look angry. Anger looks like guilt. Instead, they are coached to look saddened but resolute. Every outfit choice, every camera angle, and every leaked photo of the client performing a mundane, relatable task like grocery shopping or taking the kids to school is a calculated move to build public sympathy. If we look at the data from the early 2000s through 2026, the potential outcomes for those who master this media legal hybrid are vastly different from those who rely solely on courtroom skill. We see historical trends where the mere threat of a media campaign has led to settlements that are double the statutory requirements. This is because the attorney is not just negotiating for a house or a bank account. They are negotiating for the opponent's future. But what happens when the media campaign backfires? What happens when the public starts to see through the manipulation? That is where the strategy of narrative layering comes in. If one story fails to stick, the attorney has 2 or 3 more ready to go. They create a constant stream of noise so that the opposition is always reacting, always defending, and never able to mount a counteroffensive. They are kept in a state of perpetual crisis management. As we conclude this second part of our deep dive, we have seen how the dossier is built, how the seeds are planted, and how the legal complaint is weaponized as a press release. But we are just getting started. The true genius of this historical attorney wasn't just in starting the fire. It was in how they controlled the oxygen. In the next part, we are going to look at the dark art of the third-party proxy. We will see how this attorney utilized private investigators not just to find information, but to create it, and how they turned the opponent's own friends and family against them through a process of psychological isolation. How do you win when your own inner circle has been infiltrated by the media machine? The answer is more chilling than you might think. We will be deconstructing the mechanics of the digital surveillance era, and how a 2026 divorce can be won or lost before you even realize your phone has been compromised. The war is moving from the front page to the very palm of your hand. To master the palm of the hand is to master the modern soul. In the year 2026, the historical attorney's playbook has evolved from leaked physical folders to the exploitation of the digital exhaust we all leave behind. We enter the phase of the third-party proxy and psychological isolation. This is where the attorney moves from attacking the opponent directly to hollowing out their support system. Imagine a high-profile target. Let us call her Sarah Sterling, a venture capitalist in the middle of a high-net-worth separation. The attorney doesn't just wait for Sarah to make a mistake. They create an environment where every person she trusts becomes a potential liability. The first step in this tactical evolution is the use of digital forensics as a narrative engine. In 2026, we are not just talking about emails. We are talking about the metadata of a life. The historical attorney employs specialists who map the opponent's entire digital ecosystem. They analyze historical trends in geolocation data from fitness trackers, smart home logs, and even shared streaming service profiles. If Sarah Sterling claimed to be at a business conference but her smart thermostat shows the house was set to a specific preferred temperature of a known associate, that data point is extracted. It isn't just used in court. It is leaked to tech-focused tabloids as a story about the hypocrisy of the elite. This creates a case study in digital entrapment. The attorney understands that in the current year, a person's digital shadow is often more believable to a jury and the public than their actual testimony. Next, we look at the strategy of the infiltrated inner circle. One of the most devastating historical trends in elite divorce is the flip. The attorney identifies the weak links in the opponent's social chain. The disgruntled former nanny, the passed-over personal assistant, or the cousin who feels slighted by the family fortune. Step by step, the legal team or their intermediaries build a bridge to these individuals. They don't offer bribes, which would be illegal and unethical. Instead, they offer a platform. They convince these proxies that they are doing the right thing by speaking out against Sarah's alleged character flaws. This is the creation of the echo chamber of betrayal. When Sarah opens a news app and sees a quote from an unnamed close source regarding her private habits, the psychological impact is catastrophic. It leads to isolation. She stops calling friends. She stops trusting her staff. She becomes paranoid, and a paranoid litigant is a litigant who makes mistakes during depositions. This leads us into the high retention mechanic of the artificial crisis. The attorney knows that a calm opponent is a dangerous one. To break the stalemate, they might engineer a situation that requires an immediate public response from the target. Imagine Sarah is preparing for a crucial board meeting. Suddenly, a story breaks in a niche financial blog suggesting her divorce is causing a liquidity crisis for her firm. It is a calculated lie disguised as a concern. Sarah now has two choices: ignore it and let the rumor grow, or address it and bring more attention to her divorce. This is the double bind. Case studies show that when an attorney can force the opponent to fight on two fronts, the legal front and the professional front, the potential outcomes almost always favor a rapid, lopsided settlement. The opponent pays the premium just to regain their professional focus. Expanding on this, we must discuss the shadow PR firm integration. Historically, top-tier divorce attorneys began retaining PR firms on a white-label basis. These firms don't represent the client. They represent the story. In 2026, this involves the deployment of micro-influencers and bot networks to tilt the sentiment of a news cycle. If a major publication runs a neutral story about the divorce, the shadow PR firm ensures the comment section and social media replies are flooded with the specific narrative. They might highlight Sarah's wealth as a sign of greed, or use the historical trend of vilifying successful women to turn public sentiment against her. This isn't about changing the minds of the judge. It's about changing the air the judge breathes. Judges are human. They read the news, they see the trending topics, and they are subconsciously influenced by the cultural winds. Let us dive deeper into the step-by-step detail of the document dump. This is a classic tactic refined for the high-speed digital age. The attorney waits for a moment when the opponent is most vulnerable, perhaps during a holiday or a major professional milestone, and releases a massive cache of redacted documents to a friendly media outlet. The redactions are the key. By redacting 90% of a document, but leaving one inflammatory sentence visible, the attorney forces the public to fill in the blanks with the worst possible assumptions. This is the psychology of the void. Humans are hardwired to assume the hidden information is more scandalous than it actually is. By the time the full, boring truth is revealed months later in a courtroom, the public has already moved on, and the damage to the opponent's brand is permanent. Consider the scenario of the tactical surveillance reveal. In a historical case study, the attorney had private investigators follow the opponent for months, not to find a smoking gun, but to document a pattern of mundane neglect. They filmed the opponent missing a child's soccer game or staying out late at a bar. Individually, these are not legal grounds for anything. However, when edited together into a 3-minute montage for a media outlet, it creates a powerful visual narrative of a person who has checked out of their responsibilities. This is the cinematographic weaponization of evidence. The attorney understands that a video clip is 1,000 times more effective in the court of public opinion than 100 pages of testimony. They are not just practicing law. They are producing a documentary where the opponent is the villain. Now, imagine the impact of the controlled leak of financial disclosures. In the United States, most financial records in a divorce are supposed to be confidential. But there are ways around this. The attorney might include sensitive financial data in a motion that is technically public record, knowing that a reporter is already waiting at the courthouse to grab the file the moment it is logged. This bypasses the privacy protections. Suddenly, Sarah Sterling's private investment strategies, her net worth, and her spending habits are public knowledge. This is particularly effective against targets who value their privacy above all else. For many of the elite, the threat of their financial laundry being aired is more terrifying than the loss of the money itself. As we reach the midpoint of our deep dive into the historical attorney's media machine, the walls are closing in on our hypothetical targets. We have seen how the digital shadow is weaponized, how the inner circle is compromised, and how the news cycle is manipulated to create a state of perpetual crisis. But there is an even more aggressive layer to this strategy. It involves the use of the judicial system itself to amplify the media damage, a process known as litigation as performance art. In the next part, we will examine how the attorney uses the actual courtroom hearings as a stage for the media, including the calculated use of the empty chair and the strategic timing of witness testimony to ensure the most damaging claims hit the 6 p.m. news. We will also explore the devastating tactic of the character witness ambush, where people from the opponent's past are brought in not to testify on the law, but to provide the media with the ultimate gotcha quote. The trial hasn't even officially started, yet the verdict in the court of public opinion is already being written in ink. The court of public opinion is a theater, and the historical attorney we are analyzing is the ultimate director. To understand part 4 of this masterclass, we have to look at litigation as performance art. This is the stage where the legal team transitions from behind-the-scenes leaks to overt courtroom theatrics designed specifically for the lens of the news camera. In 2026, the optics of a courtroom appearance are more influential than the legal arguments presented within them. The attorney understands that while the judge is the one who signs the order, the media is the one that sets the price of the settlement. The first tactical pillar of this phase is the choreography of the courthouse arrival. This is a meticulously planned event. Imagine our target, Julian Vane, arriving for a preliminary hearing. The attorney representing his spouse has already tipped off the local press corps. But they do not just tell them the time. They coordinate the visual narrative. The spouse is coached to arrive 5 minutes after Julian. While Julian might try to duck in through a side entrance, the attorney ensures their client walks directly through the front gauntlet of cameras. They are surrounded by a diverse support group, perhaps a religious leader, a well-known community advocate, or simply their children's caregiver. This is the visual representation of being on the side of the angels. Historical trends show that the imagery of a lone, wealthy man being confronted by a dignified, supported woman creates an immediate emotional bias in the viewer before a single piece of evidence is discussed. Next, we dive into the strategy of the speaking motion. In standard U.S. legal practice, many motions are decided on paper. However, this attorney will fight for oral arguments on even the most mundane procedural issues. Why? Because an oral argument provides a public platform. They use these hearings to read inflammatory allegations into the record. Even if the judge eventually deems the allegations irrelevant to the final division of assets, the reporter in the gallery has already typed them out. The attorney uses the courtroom as a safe harbor for character assassination. Under the fair report privilege, news outlets can quote anything said in open court without fear of a libel suit. This creates a case study in legal laundering, taking a private, unverified rumor and turning it into a public, reportable fact by simply saying it out loud in front of a court reporter. Step by step, the attorney also employs the empty chair tactic. In 2026, high net worth individuals often try to avoid appearing in person for minor hearings, sending their associates instead. The historical attorney turns this into a narrative of arrogance. They will make a point of glancing at the empty seat where the opponent should be, then sighing audibly or making a comment to the press afterward about how the opponent considers themselves above the law or too busy with their global empire to care about their family. This creates a recurring theme of abandonment and elitism. The media picks up on this immediately, often running side-by-side photos of the spouse sitting in the courtroom looking vulnerable, and an older photo of the opponent on a private jet or at a gala. The contrast is devastating for the opponent's brand. We must also analyze the timing of the witness ambush. This is not about the strength of the witness's testimony, but the timing of their appearance relative to the news cycle. If the attorney has a particularly damaging witness, say a former accountant who can speak to Julian Vane's hidden art collection, they will save that witness for a Tuesday morning. Why? Because it ensures the story dominates the Tuesday evening news, the Wednesday morning papers, and the midweek long-form digital analysis. Historical data suggests that information released at the start of the week has a 40% higher chance of being picked up by national syndicates compared to information released on a Friday afternoon, which often gets buried in the weekend lull. The attorney is essentially programming the news cycle like a television executive. Another high-stakes element is the weaponization of the gallery. In high-profile U.S. cases, the attorney may subtly encourage certain individuals to sit in the public gallery during hearings. This could include activists related to the opponent's industry, or even people who have had legal disputes with the opponent in the past. To the cameras, it looks like a grassroots movement of people standing against the opponent. This creates a sense of systemic failure on the part of the target. Imagine Julian Vane looking behind him and seeing a row of former employees he laid off 3 years ago, all invited there by the spouse's legal team. The psychological pressure of being stared down by your past mistakes, while trying to litigate your future, is a form of mental warfare that frequently leads to settlement exhaustion. Then there is the briefing the sketch artist technique. In courtrooms where cameras are prohibited, the courtroom sketch becomes the only visual record. Historical accounts of elite attorneys suggest they would sometimes interact with sketch artists, ensuring the artist notices certain details, the opponent's scowl, their expensive watch, or the way they appear to be ignoring their spouse. In 2026, these sketches are digitized and go viral instantly. A sketch that makes an opponent look cold and calculating can do more damage to their public image than a 10-minute monologue by a news anchor. It is about controlling every single sensory input that the public receives. Let us look at a case study involving a historical U.S. political figure. During their divorce, the attorney realized the opponent was heavily reliant on a specific demographic of voters. Every legal motion filed was tailored to alienate that specific demographic. If the voters valued thriftiness, the filings focused on the opponent's secret luxury lifestyle. If they valued transparency, the filings focused on the complexity of their offshore trusts. This is the surgical alienation strategy. By the time the case reached its peak, the opponent's internal polling showed that their political career was in jeopardy, unless they ended the divorce headlines immediately. They didn't settle because the law was against them. They settled because their livelihood was being dismantled brick by brick. Finally, we have to discuss the post-hearing press conference. The attorney never just leaves the courthouse. They stop at the microphones. They don't give a long speech. Instead, they provide a 3-sentence soundbite that is perfectly crafted for a social media clip. They use the technique of moral high grounding. They will say something like, "Today was a difficult day for my client, but we are confident that the truth will eventually come to light." This implies that the current truth being told by the other side is a lie, without actually saying it. It maintains the open loop in the public's mind, making them wait for the next hearing to see what this mysterious truth might be. As the litigation moves forward, the pressure becomes an all-encompassing force. The opponent finds that their professional associates are being subpoenaed, not because their testimony is needed, but because the attorney wants the media to report that Julian Vane's business partners are being dragged into his messy personal life. This is the collateral damage phase. In the next part, we will explore the extreme measures of the financial deep freeze. We will see how the attorney uses the media to create a narrative of financial instability that triggers actual bank audits and loan recalls, turning a private divorce into a full-scale corporate crisis. We will look at how the attorney navigates the thin line between legal advocacy and economic sabotage, and what happens when the opponent's empire starts to crumble under the weight of 1,000 headlines. The endgame is approaching, and the stakes are no longer just about a marriage. They are about the survival of an entire legacy. The transition from reputation management to economic warfare marks the midpoint of the historical attorney's strategy. This is where we enter the phase of the financial deep freeze. In the high-stakes ecosystem of 2026, wealth is rarely just cash in a vault. It is a complex web of credit lines, investor confidence, and asset liquidity. The attorney understands that if you can freeze the gears of an opponent's financial machine through media pressure, you don't need a judge to award you the money. The opponent will offer it just to restart their life. Imagine our target, Julian Vane, whose net worth is largely tied up in his position as a majority stakeholder in a green energy firm. The attorney's goal isn't just to find out what he owns, but to make what he owns toxic in the eyes of the market. The first tactic in this economic assault is the strategic creditor alert. This isn't a direct phone call to a bank, which could be seen as tortious interference. Instead, the attorney uses the media to broadcast a narrative of financial instability. They might file a motion for an emergency freeze on marital assets, alleging that Julian is dissipating funds or hiding assets in offshore shell companies. This filing is immediately leaked to financial news outlets. When a major creditor or a bank's compliance department sees a headline in a reputable financial journal suggesting that a primary borrower is under investigation for asset shielding, they don't wait for a verdict. They trigger a standard risk assessment. Historical trends show that banks often respond by freezing revolving credit lines or demanding additional collateral. By using the media to trigger a bank's internal safety protocols, the attorney creates a real-world liquidity crisis for Julian without ever having to prove a single allegation in court. Next, we must analyze the weaponization of the forensic audit announcement. In many historical case studies, the attorney will publicly announce the hiring of a high-profile, celebrity forensic accountant, someone known for uncovering the hidden billions of oligarchs and dictators. The announcement itself is the weapon. It sends a message to Julian's business partners that the attorney is going to go through every line item of the last 10 years of business dealings. This creates what we call partner paranoia. Julian's associates begin to worry that their own tax strategies or private business arrangements will be swept up in the subpoena dragnet. Step by step, the attorney is socially and economically isolating the target. When Julian's partners start receiving letters from their own legal departments advising them to distance themselves from him until the divorce is settled, the settlement pressure reaches a fever pitch. Let us look at a case study from the mid-2010s involving a real estate mogul. The attorney realized the mogul was in the middle of a delicate refinancing deal for a skyscraper in Chicago. By timing a series of media-heavy filings to coincide with the closing period of that loan, the attorney effectively held the mogul's entire portfolio hostage. The lenders, wary of the negative publicity and the potential for a court-ordered lien on the property, paused the funding. The mogul was facing a catastrophic default on his other obligations. In that moment, the legal merits of the divorce became irrelevant. The only thing that mattered was the survival of his empire. He settled for an amount significantly higher than the prenuptial agreement dictated, purely to secure a media blackout and allow his loan to close. This is the art of the financial chokehold. The 2026 evolution of this tactic involves the exploitation of ESG, environmental, social, and governance metrics. The attorney knows that modern corporations are terrified of being associated with individuals who have a poor social standing. If the attorney can frame the divorce through the lens of social misconduct or systemic ethical failures, they can trigger an ESG audit of Julian's company. This is the institutional lever. They might leak stories to trade publications that suggest Julian's private behavior is a liability to the company's brand values. When the institutional investors, the pension funds, and the massive asset managers start asking questions during earnings calls about the CEO's personal legal troubles, the board of directors is forced to act. Julian is no longer just fighting his spouse, he is fighting his own board. Expanding on this, we have the technique of the lifestyle audit contrast. The attorney uses the media to paint a picture of Julian's perceived extravagance versus the client's perceived sacrifice. They will leak a list of Julian's private jet hours, his wine cellar inventory, or his collection of vintage watches. This is then contrasted with stories of the spouse having to downsize or struggle with the sudden removal of family resources. In the United States, where wealth inequality is a sensitive cultural topic, this narrative turns the public and the potential jury pool against the wealthy litigant. Historical data suggests that when a litigant is seen as a spendthrift during a divorce, judges are more likely to grant larger temporary support orders to prevent what they perceive as an unfair shift in the status quo. Consider the scenario of the tactical subpoena of the board. The attorney doesn't just subpoena Julian. They subpoena the members of his board of directors for their depositions. They know that these high-level executives will do almost anything to avoid being dragged into a deposition room to answer questions about Julian's personal life. The attorney then ensures the media knows exactly when and where these board members are scheduled to appear. The prospect of having the chairman of the board photographed by paparazzi entering a divorce lawyer's office is often enough to make the board lean on Julian to settle the case immediately. It is a form of professional extortion disguised as legal discovery. Furthermore, we must discuss the digital asset siege. In 2026, much of a target's wealth may be in cryptocurrency, NFTs, or private equity in tech startups. These assets are notoriously difficult to value and even harder to divide. The historical attorney uses the media to create a narrative that these assets are being used for money laundering or tax evasion. They might leak a story about an anonymous crypto wallet linked to Julian that has seen significant activity since the divorce was filed. Even if the wallet belongs to someone else, the mere association in a news story can trigger an investigation by the IRS or the SEC. Now Julian is facing a multi-front war. A divorce, a corporate coup, and a federal audit. The psychological weight of this is designed to create a total collapse of the opponent's will to fight. As the financial walls close in, we see the potential outcomes shifting. The attorney has successfully turned Julian's greatest strength, his wealth and his company, into his greatest vulnerability. Every asset is now a liability. Every partner is now a potential witness. Every bank is now an auditor. The strategy has moved beyond the courtroom and into the very infrastructure of Julian's life. But there is a final, even more personal stage of this media campaign that we have yet to uncover. It is the strategy of the legacy eradication. This is where the attorney moves to ensure that even if Julian survives the divorce, his name is forever tarnished in the history books of his industry. In the next part, we will examine how the attorney uses historical archives, former biographers, and even the opponent's own philanthropic history to rewrite their life story in real time. We will look at the use of the cancel culture mechanism as a legal tool, and how a 2026 divorce can result in a person being completely erased from the very industry they helped build. The price of the settlement is no longer just money. It is the right to keep your own name. We have reached the phase of the legacy eradication, a psychological and professional scorched earth policy that goes beyond assets and moves into the territory of identity. In the year 2026, a person's name is their most valuable currency. It represents decades of networking, brand building, and philanthropic weight. The historical attorney we are studying understood that while you can recover from a $50 million loss, you rarely recover from being turned into a cultural pariah. This stage of the media campaign is designed to rewrite the opponent's past so they have no future. Imagine Julian Vane, who has spent 20 years building a reputation as a visionary in green tech and a pillar of the community. The attorney's goal is to ensure that when anyone searches Julian Vane in 2026, the first 3 pages of results are not about his innovations, but about his alleged moral and ethical bankruptcy. The first tactic in legacy eradication is the philanthropic decoupling. Most high-net-worth individuals in the United States maintain their social standing through board seats at museums, universities, or hospitals. The attorney begins a coordinated outreach, not directly, but through media intermediaries, to the press offices of these institutions. They leak information that suggests Julian's contributions were sourced from marital assets he is now trying to hide, or worse, that his personal conduct is antithetical to the institution's mission. Historical trends show that institutions are incredibly risk-averse. The moment a museum perceives that a donor's divorce is becoming a PR liability, they move to distance themselves. Case studies from the last decade reveal that once the first board asks a high-profile litigant to take a leave of absence, a domino effect occurs. Within weeks, Julian finds himself stripped of the titles that provided him with social cover and elite networking opportunities. Next, we look at the weaponization of the archive. The attorney hires researchers to go back 10, 15, or even 20 years into Julian's public record. They look for old interviews, keynote speeches, or social media posts that can be recontextualized through the lens of the current divorce allegations. If Julian once gave a speech about the importance of transparency, the attorney leaks that clip alongside a legal filing alleging he is using offshore trusts. This creates the narrative of the lifelong hypocrite. By framing the opponent as someone who has been lying to the public for their entire career, the attorney makes the current divorce claims feel like the final, inevitable reveal of their true character. Step by step, the attorney is not just litigating a marriage, they are performing an autopsy on Julian's entire public life. This leads us to the high-stakes strategy of the documentary leak. In 2026, long-form video content is the most effective way to cement a narrative. The attorney may facilitate the creation of a mini-documentary or a deep-dive video essay by a popular independent journalist. They provide the journalist with unprecedented access to the spouse, family photos, and carefully selected legal documents. This isn't a news clip. It is a cinematic production that paints the spouse as a survivor and Julian as a calculated predator. By the time Julian's legal team can issue a rebuttal, the video has 3 million views and has been shared by influencers across every platform. This is the use of the viral outrage cycle as a legal leverage point. The attorney knows that the public doesn't care about the nuances of equitable distribution laws. They care about the story of the hero versus the villain. Let us examine the case study of a historical U.S. fashion mogul, whose divorce became a case study in industry erasure. The attorney realized the mogul's brand was built on a specific image of family values. The media campaign didn't focus on the money. It focused on the mogul's private disparagement of the very demographic that bought their clothes. By leaking internal emails to trade journals, the attorney triggered a consumer boycott. The mogul's retail partners, fearing a drop in sales, began canceling orders. The mogul was forced to settle the divorce for an astronomical sum just to get a signed non-disclosure agreement and a public joint statement that could be used to pacify their retail partners. This is the economic sabotage through brand contamination. The 2026 version of this involves the use of the SEO siege. The attorney employs search engine optimization specialists to ensure that the most damaging stories, the ones with the most inflammatory headlines, are the ones that stay at the top of the search results. They use link building and social signals to keep the scandal fresh in the eyes of the algorithms. This creates a digital prison for Julian. Even if he wins the legal battle, he loses the digital war. Every time he tries to start a new business or join a new board, the SEO siege ensures his past is the first thing people see. Historical data suggests that this tactic is one of the primary drivers of settlement exhaustion, where the litigant gives up just to stop the daily psychological toll of seeing their reputation dismantled in real time. We must also discuss the strategy of the professional witness parade. The attorney doesn't just call experts on finance. They call character experts from Julian's industry. They might find a former mentor or a peer who is willing to go on record, and on camera, to express their disappointment in Julian's behavior. This is particularly effective in tightly knit industries like Silicon Valley, Wall Street, or Hollywood. When the industry leaders start speaking out, the target is effectively blacklisted. The attorney understands that in the United States, professional survival depends on a network of trust. By systematically poisoning that network, the attorney makes it impossible for Julian to function in his professional sphere. Consider the scenario of the biographical ambush. If Julian was in the process of having a biography or a major profile written, the attorney reaches out to the author or the publication. They offer the other side of the story, backed by documents that the author cannot ignore. This turns Julian's own legacy-building project into a weapon against him. Instead of a celebration of his life, the book becomes a catalog of his failings. This is the ultimate form of legacy eradication, taking the opponent's own attempt at immortality and turning it into a permanent record of their disgrace. As we analyze these historical trends, a clear pattern emerges. The attorney is not looking for a fair outcome under the law. They are looking for total surrender. They are creating a world where the only way Julian can stop the bleeding is to give the attorney's client exactly what they want, plus a premium for the silence that follows. The settlement becomes a ransom payment for what is left of Julian's life. Potential outcomes for those who refuse to settle in this phase often include total professional bankruptcy and permanent social exile. But what happens when the opponent decides to fight back using the same tactics? What happens when we enter the phase of the media Cold War, where both sides are leaking, both sides are using PR firms, and the entire legal process descends into a chaotic battle of competing narratives? In the next part, we will explore the mutually assured destruction phase of high-profile divorce. We will see how the media handles a war of the roses in the digital age, and the specific historical moment when the press begins to turn on the attorneys themselves. We will look at the risks of overexposure and the tactical retreat, knowing when to pull back the media pressure before it consumes your own client. The war is entering its most volatile stage, where one wrong leak can destroy everyone involved. The media Cold War begins when the opponent stops retreating and starts firing back with their own specialized PR artillery. In this phase, the historical attorney's primary challenge shifts from offense to containment. When we look at a 2026 scenario involving Julian Vane, the situation escalates when Julian hires his own high-profile litigation PR firm to counter the narratives of his spouse. Now the media is no longer a megaphone for one side. It is a battlefield of competing leaks, where the public is subjected to two equally aggressive and contradictory truths. This is the stage of mutually assured destruction, or MAD. The first dynamic of the media Cold War is the counter-leak. For every story the attorney plants about Julian's offshore accounts, Julian's team counters with a story about the spouse's own financial irregularities or past indiscretions. This creates a state of narrative exhaustion in the public. When the audience is hit with too much conflicting information, they don't know who to believe, and the initial impact of the attorney's campaign begins to dilute. Historical trends show that during this phase, the potential outcomes shift toward a stalemate. The attorney must now decide if they want to double down on the aggression or pivot to a more sophisticated form of psychological warfare. The false flag leak. In a false flag leak, the attorney might intentionally leak a piece of information that seems damaging to their own client, but is actually a trap. They release a story that is easily disprovable. When Julian's team jumps on the story and amplifies it, the attorney then releases the definitive proof that the story was false. This destroys the credibility of Julian's PR team and the journalists who carried their water. It is a high-risk, high-reward maneuver designed to discredit the opponent's entire media operation in one fell swoop. We see case studies where this specific tactic has ended a media war instantly, as the press becomes terrified of being manipulated and refuses to run any more stories from the opponent's camp. Next, we must examine the saturation point and the risk of overexposure. There is a law of diminishing returns in media campaigns. If the public hears about the Vane divorce every day for 6 months, they stop being outraged and start being annoyed. They begin to see both parties as entitled elites wasting public attention. The historical attorney is a master of monitoring this sentiment. They use social listening tools to track the fatigue index of the story. If the sentiment starts to turn against the process itself, the attorney will initiate a tactical retreat. They will suddenly stop all leaks, decline all interviews, and release a statement saying their client wants to prioritize the privacy of the family. This isn't out of the goodness of their heart. It is to let the public's anger at the opponent simmer while the attorney's client looks like the one trying to take the high road. This leads us into the step-by-step mechanics of the news cycle starvation. By cutting off the supply of information, the attorney forces the media to look elsewhere. But because the opponent is still in a reactive mode, they often continue to leak, which now makes them look like the aggressor who won't let the matter rest. It is a brilliant psychological pivot. The attorney turns their client from a media brawler into a silent victim in the span of a weekend. Historical data suggests that the party that stops leaking first, after already doing significant damage, is often perceived by the court and the public as the more reasonable actor. We also need to discuss the secondary market of the media war. The industry trades. While the general public might be getting bored, the specific industry Julian Vane operates in, green tech, is still watching closely. The attorney will transition from the New York Post to technical journals and industry blogs. They will plant stories not about Julian's personal life, but about his professional competence. They might question the technical viability of his latest patent or suggest that his legal distractions are causing him to miss critical market shifts. This is the professional siege. It is quieter than a front-page scandal, but for a man like Julian, it is far more dangerous. It attacks his soul, his work, by making him feel like his professional legacy is being dismantled by inches in the very journals he used to respect. The attorney keeps the pressure high even when the mainstream media has moved on to the next celebrity scandal. Consider the case study of a historical U.S. shipping magnate. In his divorce, both sides were spending over $100,000 a month on PR consultants alone. The media war became so intense that the journalists themselves became part of the story. Reporters were being accused of taking bribes or being too close to the attorneys. This is the meta-scandal phase. When the press becomes the story, the actual legal issues of the divorce are completely lost. The attorney we are analyzing was known for being able to step out of this chaos just before it consumed the legal team. They would use a cutout, a third party who could take the blame for any aggressive tactics that backfired, ensuring that the attorney's personal reputation with the judge remained intact. Expanding on this, let us look at the 2026 use of artificial intelligence in narrative management. The attorney's team uses AI to predict which stories will gain the most traction, and which will likely cause a backlash. They run simulations of how a specific leak will play out across different social media demographics. This allows for a level of precision that was impossible 10 years ago. They can tailor a leak to specifically target the investors in Julian's company, without ever alerting the general public. This is narrowcast character assassination. It is like a sniper rifle compared to the shotgun approach of a tabloid headline. The attorney is able to apply pressure to Julian's most sensitive financial points with surgical accuracy. Step by step, the attorney also manages the legal media feedback loop. This is where the media coverage is used as evidence in the courtroom. The attorney will present the news stories, the ones they themselves planted, to the judge as proof of the public interest in the case or as proof of the opponent's declining reputation, which might affect their ability to pay future support. It is a perfect self-sustaining cycle of manipulation. You create the news, then you use the news to argue for a legal advantage, which then creates more news. As the media Cold War reaches its peak, the psychological toll on both parties is immense. This is the phase where settlements are often reached in the middle of the night, driven by pure exhaustion. But for our historical attorney, there is one final move before the settlement papers are signed. It is the move that ensures the opponent never thinks about reopening the case or speaking ill of the client ever again. It is the creation of the permanent deterrent. In the next part, we will explore the vault strategy, the collection of information that is never intended to be leaked, but is held as a lifetime insurance policy. We will look at how the attorney secures the future through the management of non-disparagement clauses that are backed by the threat of total social annihilation. The war might be ending, but the occupation is just beginning. How do you live a life when a legal team owns your most dangerous secrets in perpetuity? That is the dark reality of the endgame. The endgame of a high-profile media campaign is not marked by a courtroom victory, but by the establishment of a permanent deterrent. This is what historical analysts refer to as the vault strategy. In the world of 2026, where data is permanent and the internet never forgets, the historical attorney we are documenting transition from using information as a weapon to using it as a leash. The goal is to create a state of perpetual compliance. Imagine Julian Vane at the final negotiation table. He is exhausted, his stock price has stabilized but remains fragile, and his social circle has been pruned to a handful of loyalists. He is ready to sign anything to make the headlines stop. But the attorney has one final layer of protection for their client: the material that was never leaked. The vault strategy relies on the principle of credible threat. During the discovery and media seeding phases, the attorney gathered far more information than they actually used. They hold a repository of Julian's most sensitive vulnerabilities, perhaps records of a private health struggle, unvetted business communications that skirt the edge of regulatory compliance, or compromising personal correspondence that has nothing to do with the divorce but everything to do with his dignity. By explicitly not leaking this information during the heat of the battle, the attorney has demonstrated a terrifying level of self-control. They show Julian that they have the power to destroy him utterly but have chosen to hold back. This creates a psychological weight that historical trends show is more effective than any court-ordered injunction. This leads into the technical execution of the non-disparagement ironclad. In a standard U.S. divorce, a non-disparagement clause is often a toothless paragraph. However, this attorney constructs a multi-layered legal and media fortress. The agreement is tied to significant financial penalties, but more importantly, it is tied to the vault. The step-by-step detail of this involves a clawback provision. If Julian, even 5 years from now in 2031, speaks ill of the settlement or the spouse in an interview, a pre-negotiated portion of his remaining assets is forfeited. But the real deterrent is the unwritten understanding. If the agreement is breached, the vault opens. This turns the settlement into a lifetime of monitored silence. To understand the depth of this, we must look at the case study of a historical U.S. media mogul from the early 2010s. The divorce was settled quickly and quietly after an initial burst of explosive headlines. For a decade, the mogul never breathed a word of the conflict. It was only years later that it surfaced that the attorney had secured a digital forensic mirror of the mogul's personal server. The settlement wasn't just about the division of property. It was a licensing agreement for the mogul's own privacy. This is the concept of privacy as a subscription. In the year 2026, this is managed through sophisticated escrow services where encrypted data is held by a third party, only to be released if specific contractual triggers are met. Julian Vane isn't just buying his freedom. He is leasing the silence of the legal team. Furthermore, we must analyze the strategic rehabilitation phase. Once the settlement is signed, the attorney's media machine doesn't just shut down, it reverses polarity. To ensure the client's long-term security, Julian must be rehabilitated in the public eye. Why? Because a disgraced, bankrupt Julian is a Julian with nothing left to lose. A person with nothing to lose is dangerous and unpredictable. Therefore, the attorney facilitates a soft landing for the opponent. They might leak a story to a business journal about Julian's resilient leadership or his visionary return to form. This is the golden bridge strategy. You build a bridge for your enemy to retreat across, so they don't feel forced into a corner where they might fight to the death. Step by step, the attorney manages the transition from the media war to a scripted piece. This involves the use of the joint statement as a narrative cap. The attorney writes a final, perfectly balanced press release. It uses phrases like mutual respect, focus on the children, and private matter. This statement is designed to be the final word that search engines index. It acts as a digital lid on the boiling pot of the last 6 months. Historical data suggests that when both parties release an identical, boring statement, the media's interest drops by 85% within 48 hours. The story is dead because the conflict is gone. The attorney has successfully managed the entire life cycle of the scandal, from the first spark to the final extinguishing of the embers. Now, consider the scenario of the shadow monitoring. In 2026, the attorney's work doesn't end with the final decree. They maintain a digital watchtower. They use automated tools to monitor any mention of the client or the case across the global media landscape. If a small blog in another country picks up a piece of the vaulted information, the attorney's team is alerted instantly. They don't always use a lawsuit to stop it. They might use their media influence to have the story buried or removed before it reaches the US mainstream. This is the ongoing service of reputational maintenance. The client pays a retainer not for legal advice, but for the continued security of the narrative. The potential outcomes for a client represented by this type of historical attorney are vastly different from those in a standard litigation. They don't just walk away with a check. They walk away with a clean slate and a silenced opponent. But the cost is total. This is not just a financial cost, but a moral and systemic one. By bypassing the transparency of the judicial system through media manipulation and private deterrence, this process creates a parallel legal system for the elite, one where the truth is whatever the most expensive PR firm says it is. As we look at the data of these historical trends, we see that the most successful campaigns are the ones that the public forgets the fastest. The ultimate mark of a masterclass media attorney is that 2 years after the divorce, the public can't quite remember why they were ever mad at the parties involved. The scandal has been sanded down, polished, and hidden away. Julian Vane returns to his boardrooms, the spouse returns to their private life, and the attorney moves on to the next high-net-worth individual who needs a reality manufactured. But there is a lingering question that haunts the edges of this strategy. What happens when the vault is compromised? In an era of decentralized hacking and whistleblowers, no secret is truly safe forever. In the next part, we will explore the nightmare scenario, the breach of the vault. We will see what happens when the very information used as a deterrent is leaked by a third party, and how the attorney handles a crisis that they can no longer control. We will look at the legal and ethical fallout of the black box of divorce law, and the historical moment when the system finally began to push back against these media-driven tactics. The war may have a winner, but the fallout is unpredictable. The final reckoning is coming, and it will challenge everything we think we know about the intersection of law and the Fourth Estate. The unpredictability of the digital age means that even the most secure legal vault has a failure point. We are now entering the phase of the narrative collapse and systemic backlash. This is the moment in our historical analysis where the precision-engineered media machine grinds against a reality it can no longer manipulate: the decentralized whistleblower and the rogue data breach. Imagine Julian Vane, 3 months after signing his ironclad settlement, sitting in his redesigned glass office. He believes the war is over. But across the world, a decentralized hacking collective or a disgruntled former IT contractor from the law firm decides that the secrets of the elite should not be used as leverage. They release the entire vault, the raw, unedited, and highly damaging files that the attorney used as a silent deterrent. This is the nightmare scenario of the secondary crisis. In the year 2026, information is like water. It finds every crack. When the vault is breached, the historical attorney faces a challenge that traditional crisis management cannot solve. The data is out there and it is unverified, chaotic, and viral. This leads to a historical trend we call the credibility implosion. Because the attorney spent months carefully curating a specific public image for their client, the revelation of the raw data, which often contradicts that image, creates a backlash far more severe than the original scandal. The public feels manipulated. The media outlets that were previously allies now turn on the attorney to save their own reputations, claiming they were misled by a sophisticated disinformation campaign. Step by step, we see the mechanics of the judicial pivot. When a media campaign becomes this toxic, the court system often feels the need to reassert its authority. Judges, sensitive to the accusation that their courtrooms have been used as stages for PR stunts, may initiate sanctions or move to unseal previously protected records to ensure transparency. Historical case studies show that when the media war spills over into a public scandal involving the legal process itself, the court's primary goal shifts from adjudication to institutional preservation. For Julian Vane, this potential outcome is catastrophic. The settlement he paid a premium to secure could be challenged on the grounds of duress or fraudulent concealment of information revealed in the breach. Let us look at a case study involving a historical U.S. political dynasty. During a high-profile dissolution, the legal team utilized a heavy-handed media strategy that involved suppressing certain witnesses through NDAs. However, a digital leak revealed the existence of these hush agreements, leading to a federal inquiry into potential witness tampering. The legal battle moved from a family court in Delaware to a congressional hearing room in Washington, D.C. This is the transition from a private dispute to a matter of public interest. The attorney, once the hunter, becomes the hunted. They are no longer arguing about asset splits. They are defending their law license against ethics committees and state bar associations. In 2026, this systemic backlash is amplified by the algorithmic acceleration of cancel culture mechanics. The attorney's client, who thought they had purchased a clean slate, finds themselves at the center of a global ethical debate. We must analyze the phenomenon of the digital stakeholder revolt. In Julian Vane's case, his company's employees, who were previously quiet, might start a grassroots movement demanding his resignation based on the leaked vault files. The media campaign that was designed to protect his professional legacy becomes the very tool that dismantles it. This is the irony of total information control. The more you try to suppress a narrative, the more explosive it becomes when it finally breaks free. Expanding on this, we look at the role of the investigative journalist as a disruptor. While the attorney was busy feeding exclusives to tabloid columnists, a serious investigative team at a major outlet like ProPublica or the Wall Street Journal was likely tracking the patterns of the media campaign itself. In several historical trends, these journalists eventually stop reporting on the divorce and start reporting on the attorney's tactics. They map the network of PR firms, the payments to influencers, and the coordinated leaks. When this meta-story breaks, it changes the cultural conversation from the specifics of the divorce to the systemic corruption of the legal media complex. The attorney's playbook is exposed, rendering their future tactics ineffective across the entire industry. Consider the scenario of the forensic data reclamation. Once the vault is leaked, the opposition, Julian Vane's spouse in this instance, may be forced to take a public stand against their own attorney's previous tactics to avoid being seen as a co-conspirator in a smear campaign. This creates a civil war within the legal team. Step by step, the alliances that were built on the premise of a shared victory begin to crumble under the pressure of public scrutiny. The attorney finds themselves isolated, as even their own client may hire a cleanup legal team to sue the original attorney for malpractice or for bringing the client's reputation into further disrepute. This leads us to the high retention concept of the regulatory reckoning. Following these types of historical media legal wars, we often see a push for new legislation. In 2026, we are seeing the potential for the Litigation Transparency Act, which would limit the use of judicial privilege for pretrial filings and require more stringent disclosures regarding the use of PR firms in active litigation. The historical attorney we are documenting has, through their very success, created the conditions for their own obsolescence. They have pushed the boundaries so far that the system is forced to snap back and recalibrate the rules of engagement for everyone. As we reach the penultimate part of this masterclass, we see that the master of the media war has become a victim of the very chaos they sought to harness. The fallout is not just professional, it is existential. The attorney's brand, once synonymous with winning at all costs, becomes a liability. New clients, fearing the same type of vault breach or systemic backlash, begin to seek out attorneys who prioritize quiet, old-fashioned mediation over the high-octane media circus. The era of the viral divorce attorney begins to wane as the market corrects for the extreme risks involved. But there is one final chapter to this story. We have seen the rise, the tactics, the peak of the war, the endgame of the vault, and the collapse of the system. In the final part of this series, we will look at the ultimate legacy of the historical U.S. divorce attorney. We will examine the post-war landscape, what happens to the people, the firms, and the laws 10 years after the dust has settled. We will ask the final, most important question: was any of it worth it? We will look at the human cost of the media war, the psychological toll on the children caught in the crossfire of these headlines, and the final state of Julian Vane's once mighty empire. The masterclass concludes with the most sobering lesson of all: the difference between winning a case and losing a life. The final verdict isn't delivered by a judge or a headline. It is delivered by history. History is a cold accountant, and when we look at the ledger of the historical media-driven legal practice, the final tally reveals a structural shift in the American justice system. In this final installment of our deep dive, we are examining the post-war landscape. We are looking at the wreckage left behind after the 2026 media storms have subsided and the headlines have moved on to the next generation of scandals. For Julian Vane, the man we have followed through this psychological and economic meat grinder, the conclusion of his legal battle was not the end of his ordeal. It was the beginning of a long, quiet obsolescence. When the dust finally settled, the potential outcomes for his life and legacy were permanently altered, providing a somber case study in the true cost of weaponized litigation. The first pillar of the post-war landscape is the institutional scar tissue. In the wake of high-profile media campaigns, the institutions that were once the target support system, the boards, the social clubs, the professional associations, often implement permanent policy changes. In 2026, we see the rise of the character morality clause in executive contracts. These are not the vague clauses of the past. They are specific, data-driven triggers that allow an organization to sever ties with the leader the moment a media campaign reaches a certain threshold of negative sentiment. The historical attorney's success in taking down Julian Vane inadvertently created a corporate environment where every executive is now viewed as a potential liability. This is the systemic legacy of the media war, a permanent state of institutional distrust. Step by step, we must also analyze the psychological afterlife of the litigant. The human brain is not evolved to handle the scale of public shaming that a coordinated media campaign provides. Historical trends suggest that individuals who have been through this process suffer from a specific form of reputational trauma. Julian Vane, despite his wealth and his eventual settlement, finds himself in a state of hypervigilance. He cannot enter a room without wondering who in that room has read the vault leaks. He cannot start a new venture without fearing the SEO siege will return. This is the ghost in the machine effect. Even when the legal papers are filed and the attorney is gone, the digital echo of the campaign remains. Case studies of former high-net-worth targets show a 60% decline in subsequent entrepreneurial activity, not because they lack the funds, but because they lack the social capital to recruit top-tier talent or secure favorable media coverage for new projects. Expanding on this, we look at the intergenerational fallout. One of the most hidden costs of the media legal war is the impact on the children and the extended family who were caught in the crossfire. In the 2026 digital era, these children grow up with a permanent, searchable record of their parents' worst moments. The attorney used these family dynamics as leverage in Part 4 and Part 6, but in Part 10 we see the long-term result: a fractured family legacy. Historical data from high-profile U.S. divorces indicates that the children of these War of the Roses cases often face their own reputational hurdles, as they are forever associated with the scandals of their parents. The wealth they inherit is often viewed by the public not as a gift, but as blood money from a destructive legal battle. This is the eradication of the family name. Then there is the evolution of the legal profession itself. The historical attorney we have documented represents a peak in the attorney as producer model. However, following the 2026 systemic backlash we discussed in Part 9, the industry has seen a pivot toward narrative restoration law. A new class of attorneys has emerged who specialize not in starting the fire, but in the long-term decontamination of a reputation. They work with data scientists and psychologists to slowly rebuild what was destroyed. This is a multi-year, multi-million-dollar process that most people cannot afford. It highlights the deepening divide in the United States legal system, one where the elite litigate their lives through media campaigns, and then spend the rest of their lives paying to have those same campaigns erased from memory. Let us look at a final case study involving a historical U.S. tech founder. 10 years after his media-saturated divorce, he attempted a comeback with a new revolutionary platform. Despite the technical superiority of his product, the media coverage was dominated by look-back pieces on his decade-old legal battle. The narrative was stuck. Investors were wary, not of the technology, but of the brand baggage. This is the concept of narrative stagnation. The historical attorney's work was so effective that it created a permanent ceiling on the opponent's future growth. For Julian Vane, this means that even if he develops the most efficient green energy cell in the world in 2030, the headlines will still mention the 2026 vault breach. He is a prisoner of his own history. We must also consider the ethics of the Fourth Estate. The journalists who were used as proxies in this media war also face a reckoning. In the years following these campaigns, the public's trust in traditional media often hits new lows. When it becomes clear that exclusive scoops were actually precision leaks from a legal team, the line between journalism and PR blurs into non-existence. This has led to the historical trend of the decentralized news cycle, where audiences move away from major outlets toward independent, blockchain-verified reporting, where the source of information is more transparent. The historical attorney's tactics eventually broke the very tools they relied on. They overfarmed the media landscape until the soil became toxic for everyone. Step by step, the attorney's own legacy is also subject to history's judgment. While they were once feared and sought after, the master of the media war often ends their career in a state of professional isolation. As the rules of the game change and the systemic backlash results in new regulations, the old-school tactics of the Friday night dump and the vault strategy become relics of a more lawless era. The attorney becomes a cautionary tale, a reminder of what happens when the pursuit of a legal victory comes at the expense of the integrity of the law itself. Their name becomes synonymous with a period of American legal history defined by the Great Transparency Crisis. So we return to the final question: was it worth it? For the client who walked away with a massive settlement, the answer might be yes in the short term. But when you look at the total destruction of the opponent, the trauma to the family, the corruption of the media, and the eventual erosion of their own privacy, the victory feels hollow. The historical attorney didn't just win a case. They helped create a culture where the truth is a commodity and reputation is a weapon. As we conclude this deep dive masterclass, we see that the real winner was never the attorney or the client. The real winner was the machine itself, the attention economy that thrives on conflict and feeds on the destruction of legacies. Julian Vane's story ends not with a bang, but with a quiet disappearance from the public eye. He remains wealthy, but he is no longer a visionary. He is a footnote. His spouse remains comfortable, but they are forever defined by the battle they fought. And the historical attorney moves into the shadows, their playbook now studied by students of history and law as a warning of how easily the scales of justice can be tipped by a well-placed headline. This masterclass has documented the architecture of the media war, but the story of American litigation is still being written. The tactics will evolve, the platforms will change, but the fundamental human drive for leverage will remain. As you move forward, remember that in the digital age, the trial is never truly over. Every post, every leak, and every headline is a permanent brick in the wall of your legacy. The court is always in session, and the jury is the world. We have explored the mechanics of the deep dive. Now it is up to the next generation to decide if they will continue the war or find a better way to define the peace. This concludes our 10-part documentation of the media campaigns of a historical U.S. divorce attorney. The archives are open, the data is clear, and the lessons are yours to carry.